Okay. You're all
Okay,
set, Ted. Yeah.
we're good.
Mhm.
All
I'm
right,
just choking. I'm sorry.
that was you?
Just choking.
All right. I got the YouTube
Hey,
here.
Ted.
Okay. Hey, Rick. All right, let's start. Good evening, ladies and gentlemen. Welcome to a regularly scheduled meeting of the Zoning Commission, City of Danbury, July 26, 2022, 7:30 p.m. Let the record show we will begin at 7:34 with the roll call. Commissioner Coelho,
Here.
Commissioner David. I'm going to mark as absent. Commissioner Fay,
Present.
Commissioner Hawley,
Here.
Commissioner Hylinski is absent. Commissioner Jowdy,
I'm here.
Commissioner Malillo,
Here.
Commissioner Rea is absent. Commissioner Bennett is absent. Commissioner Duran is absent. Commissioner Mahia
Here.
is here. And I'm Chairman Haddad. 1, 2, 3, 4, 5, 6, 7. We have 7. Commissioner Mahia, I'm going to sit you for the entire evening for Commissioner Rea. Thank you. The next regular meeting is scheduled for August 9th, 2022. If we all stand and if we have flags, hold them up for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, thank you. Let's go to the, well, before we do the minutes, let me read the instructions. The virtual Zoom meeting introduction. This meeting of the Danbury Zoning Commission is being held on Zoom as a virtual meeting. Even though this meeting is a virtual meeting, members of the public and interested parties continue to have the opportunity to participate in the meeting in a couple of different ways. You can participate via Zoom and see the audio and the video, or you can call in by phone and participate via audio only. Please be aware that we may have to mute your microphone or telephone to avoid an echo or some other background noise. This is also being streamed live via YouTube. Instructions on how to participate in the meeting appear on the City of Danbury website, and all of the documents and materials that apply to the matters to be discussed during this meeting, including the agenda, are also available on the City of Danbury website. As always, if you have any questions, please contact the City of Danbury Planning and Zoning Department. As a reminder, the entire meeting will be posted on and can be seen on the City of Danbury website. We will follow the posted agenda as per standard practice. If prior to the meeting, any questions or comments on agenda items are submitted via email to Sharon Calitro, those comments will be read during the appropriate portion of the meeting. Finally, please remember that technology glitches sometimes do occur. Please be patient if that happens. Commission members, everybody received their July 12th, 2022 minutes. Hopefully everyone had a chance to review them. I would entertain a motion at this time to accept those minutes. Anyone want to make a motion to accept the minutes of July 12th, 2022? Ms. Fay, thank you very much.
So moved.
And second by Mr. Jowdy. Thank you. Any discussion? All those in
No.
favor signify by saying aye.
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 All those opposed? Not hearing any. Unanimously, the minutes are accepted. We don't have any public hearings this evening. However, we do have a continuation of a public hearing. It's a petition of Sharon B. Calitro, Planning Director, to amend sections 2B, 3C4, 5A, 2B, 5A5, 5B, 2B, 5B5, 6A, 2B, 6B, 2B, 8C, 4C, 10J, 11B2, and 11B3 of the zoning regulations. In parentheses, amendments to clarify definitions of cannabis establishments, allow and regulate specific adult use cannabis establishments in specified zoning districts, establish a parking requirement, and prohibit issuance of various variances for said cannabis uses. We also provided a link that I know everyone clicked and got. It was the revised proposed amendment language, and that was from the last meeting we had on July 12th, that public hearing. We continued this not for any specific reason. So we're going to go to Ms. Calitro, and then we will field any questions to her and then go on to see what we have sitting out there. Ms. Calitro.
Thank you, Mr. Chairman. For the record, Sharon Calitro, I'm the planning director for the city of Danbury. So I'm sharing my screen. This was the link that was provided to everybody on the agenda. And what I did in red was add in the amendments that we discussed at the last, and we discussed at the last meeting. Let me just scroll down to the first. Let's see, I have to go to page 6. Bear with me. Okay, so in G, and I think I read it to you, that we just thought to help clarify, because we're clarifying how we measure everything. So we just wanted to be clear. And so we added language about how to measure the distance between one cannabis establishment to the next. So I added in the language that I read: the distance shall be measured in a straight line from the nearest legal parcel boundary of one lot to the nearest legal parcel boundary of the other lot. So that was just for clarity. On the next page, I had shown you some additional language, or some replacement language, I should say, relative to the provision that would have required a new special exception approval from the Planning Commission on the transfer of a new license. So this is just in place of what was there before. I showed this to you on the screen. I'm not going to read the entire thing. You all have it. And just also for the record, I just wanted to indicate that I did actually go back again and look at the Department of Consumer Protection regulations for adult use cannabis that became effective January 26th. So these are the regulations of state agencies, and these are kind of how they regulate. These are the policies by which they'll go by when they regulate. And so there's a provision in here that actually says that changes of the backers, key employees they shall notify the Department of Consumer Protection of any change in the name, contact information, place of employment, or any other information that's required pursuant to these regs in a form and matter prescribed by the commissioner, not more than 5 days after the change becomes effective. So this is kind of in line with, listen, if you're changing people, we ought to know. And it goes one step further by just requiring whoever's taking it over, if it is a change, that they understand that there was a special exception, there might be requirements associated with that, and that they transfer as well. So again, this is the same exact language I showed to everybody as a replacement language at the last meeting. And then finally, we made a small change in 5C. Commissioner Hawley had indicated, and he's correct, that we should just change the pronoun to their designee, chief of police or their designee. And then I added in that the applicant would have to provide information on the provision for the installation of video cameras. And I think that came up during the course of our discussion. So those are the changes, again, published with the agenda. Those are the only changes that I am proposing to the petition at this time. And so with that, unless anybody has any questions, I'll go on to try to answer the best I can the question relative to some state projections. Anybody questions?
Anybody have any questions of Ms. Calitro, commission members? I can't see hands because we got the screen here, but I don't hear any voices.
Let me take that off.
No, that's okay. I didn't hear any voices anyway. So go ahead, Ms. Calitro. Why don't you go on to the next?
So hold on, let me go back. I have to go to screen share again. This one. Okay, so you had asked me, Commissioner Merlillo had asked me if I had any projections relative to what could be expected in terms of the taxes. So I did a bunch of research. This is what appears on the Office of Fiscal Analysis on the state's website relative to some projections. And I'll go through the numbers, but as you can see, I don't actually know how to make this smaller. So, but anyway, it gives you for 5 years what the projections are. So for instance, I'll just jump to like fiscal year 26. So the funds combined results in a total state impact of 55.2 million. And with total municipal tax added, impact results in 73.4 million. So it's just a math exercise. I did this for each of the 5 years that were on here. So I took what they were projecting from a state. I took what the overall impact is. If you subtract the state from the overall, you get what they're anticipating in municipal tax revenue. And then you divide that by the number of places that would be selling recreational cannabis. So if the state intends to issue 20 new licenses, so that includes 4 microcultivators through the state over the course of the whole state, 12 retail facilities, and sorry, I'm just reading from my other notes, and 4 hybrids, that's 20, right? So they're going to issue those 20 licenses. And then the existing medical dispensaries get a license without having to go through the lottery. So that's another 18. So you take 38 facilities and you divide it into the revenue that the municipality, in the municipality column, you get what each place is expected to generate over the course of this year. So if you look at fiscal year 26 and you subtract 55.2 from 73.4, you get 18.2. You take 18.2 million, you divide it by 38 places across the state. Let's assume no other licenses are issued. So, I mean, you got to make some assumptions. This is an educated guess. You get each place generates $478,947,000 in local tax revenue. And if we allow 2 places in Danbury, it's just shy of $1 million. So, I mean, you can do that math, you know, for each of the 5 years across the board. It's ever increasing. I also did I mean, you could take what portion of the population you think might buy, how many times they might buy, what other states, you know, are selling on a per person, could be expected per person, how many times a month, do that math. It all comes out, you know, about around the same. I also, there was a question about what was going on in Massachusetts. They actually have statistics on their website on retail sales and delivery on a weekly sales basis. They have a lot of statistics. They have a lot more places selling and delivering than would be in Connecticut. But I could tell you that for the week ending 7/3/2022, as reported on the Massachusetts cannabis site, the marijuana retail and delivery weekly sales report data totaled about $31 million a week for that week ending. So overall. So again, you can extrapolate. It's just an educated guess. It kind of falls in line with some of the testimony that you received from Mr. Domenica as well, that each of the facilities could, you know, produce, I guess, or generate, I should say is a better word, could generate, you know, $6-7 million, upwards of that. You take 3% of that, and that's what the city of Danbury would collect. So again, just the best we could do is take the information that's available online. This is what the state has produced. You can see in FY21 overall, the difference between the total and the state increases from $1 million to, and again, this is just doing the math, from $1 million in FY22 to 18.2 million in FY26. These are probably conservative numbers, very conservative numbers, compared to what we're seeing in, and what's been reported, not seeing, but what I've read in reports like in New Jersey, you know, how much was sold in one day, $1.9 million in a single day when they open retail sales. Again, I don't know how many facilities are licensed to sell, but that's, you just look at it, kind of comping it across the states that are adjacent to us. So again, I know it's not definitive, but I don't think there's any way for me to give you anything definitive. I'm assuming it's in the several $100,000 range, at least at the get-go, per facility in a fiscal year for us.
So the municipality doesn't collect on medicinal.
Correct.
And a hybrid would actually have to divide up their shop to do a calculation on recreational and medicinal.
Correct. We only get the 3% tax on the recreational sold at the hybrid, not on the medicinal.
And there's actually
it's
no tax on medicinal for the municipality or the state, right?
I don't know the answer to that. I think there's tax.
Oh,
I
okay.
really don't know, but it might just be the 6.25 or 6.35. The 3% is only on the recreational, and you can only take it from the portion of the hybrid that sells recreational, and then the delivery aspect of the hybrid. So those are the only ones that sell to consumers. So those are the only establishments, for lack of better, but that the city would potentially gain some revenue from.
Yeah, I think it'll come up maybe later on, I'm sure, somebody just to
Commissioner
clarify
Miller,
the issue of whether this state even collects anything at all on medicinal.
Yeah, but we don't get any portion of
Yeah.
that.
Right. Commissioner Malillo.
Yeah, I'm piggybacking on a comment you just made, Commissioner Haddad, noting the hybrid model. I know with us knowing moving forward that we have one facility in Danbury that currently sells medicinal, which has already indicated that they want to sell recreational. So we will have that as a hybrid. Sharon, do you anticipate that they would double their sales and their traffic volume? Or is there any type of a calculation or anticipation as to how that would be impacted, how that will impact that traffic wise in that vicinity, as well as just in general revenue?
Well, let me just go back to something you said in the beginning. While they want to be a hybrid, they might have a recreational license because they're already a dispensary, a medical dispensary. Unless they met the regs that were in place, they couldn't be a hybrid. No matter what they wanted, they have to still meet our regs. Just because the state says, oh, you already existed prior to this, you just have to convert to a hybrid. They don't get that grandfathered in. That doesn't automatically happen. They would still need to meet our regulations, number one.
I understand that, but just assuming that the fact that they're going to comply with and meet the regs, and because they have every intention to trying to become that. So let's say they follow through and they do that. Would the anticipation then be that facility would have double the amount of volume, or
could have a lot of different volume than they have now?
Yeah,
right?
because
if you went by, and again, I'd have to crunch the numbers for them specifically, which I did not do. And I don't know that we need to, but you just use the traffic generator rate and see what it could potentially generate. And then you'd have to look at the volume, what's there today. Again, it's a process, but there's no doubt there'll be an increase in the people going into that facility. Now, they do have to, under their license, I think they have to separate kind of, the medicinal, the people who are going in for medicinal cannabis versus adult use, recreational.
Right, I understand that, and I understand that there would definitely be an increase. The reason I was thinking that was because in your estimation calculation, you were treated the hybrid as equal to a standalone, when you just did that simple division up. So therefore, theoretically, in my mind, that would mean that the hybrid would have two equally busy, the recreational side of a hybrid aspect would be just as busy as a standalone. And then on top of that, they still have the medicinal side. So whether that would double, or, I mean, it would definitely be an increase. It may be more than a double depending on how busy the medicinal side is. But I was just curious about that, because that could be, that, just wondering how that would play out in regards to the vehicle.
Well, I guess I guess my response to that is that was one of the reasons why I thought it would be prudent to be very conservative at the get-go. And if this was something that the zoning commission, these uses were that the zoning commission wanted, we ought to be, tread lightly in the beginning to see what happens, and not just kind of open the door to whatever number, whoever could meet whatever requirement. And so that's why we kind of put a limitation on it. Let's see what happens. I don't, we have, the state has no experience. You can only kind of ascertain from what other states went through. And it's, in a sense, no different in some aspects than, the brand new use. And I'm going to, again, compare it to, I know it's not the same, but, when Chick-fil-A opened in Brookfield, and, it's crazy there on Federal Road, it calmed down after a while. And then maybe people learn they can buy things online and they can get it delivered. I mean, there's a lot of different things that could happen. So that's why our recommendation was go slow, minimum number of establishments in the city. Let's see what happens. Let's see, what happens with the traffic generation, how things are handled, what happens with the roadways, and all of the rest.
You good, Commissioner Merlillo? Commission members, any other questions at this time of Ms. Calitro? I don't see her here. Should we go to Attorney Casagrande this time? I think he might have a couple responses. Attorney Casagrande, shall we?
Sure, Mr. Chairman.
Thank you.
I'll share my screen, Dan, for you.
Okay. Good evening. For the record, Dan Casagrande, Assistant Corporation Counsel. At the last meeting, the commission asked our office to research two general questions regarding the effect, if any, of the current federal stance on enforcing the federal criminal marijuana laws, and what effect that might have on your decision to go forward in adopting this regulation pursuant to the state program. And so what I did, and I'm not going to read this verbatim, but I prepared a memorandum, which you see on your screen. And basically, there are two questions that were asked. What's the impact of the federal law enforcement efforts, if any, on Connecticut's statutory scheme that allows local governments to regulate cannabis establishments in general, and on the zoning commission's determination of whether to permit such establishments in Danbury in particular? The second question is, does federal law prohibit the transport of marijuana legally purchased in Danbury pursuant to the proposed regulations across the state line into New York or other states? The answer to the first question, which I'll get into in a little bit more detail, is that while it's not free from uncertainty, it appears in our view unlikely that the Department of Justice would attempt to interfere with Connecticut's regulatory scheme or the commission's decision to adopt these regulations. The answer to the second question, very briefly, is that it's a federal crime to transport marijuana across state lines, even if you possess it or purchased it legally in Connecticut. Going over to the next page, what I tried to do is give a very brief overview of the history of the Controlled Substances Act and the emerging efforts of states to adopt their own regulations. As you can imagine, this was not an easy task. There are literally dozens of law review articles that have been published in the last 10 years on the interplay between the federal prohibition, which is still on the books, and the state regulatory efforts. But we were able to find a few clues as to where we think this will play out. So under the Controlled Substances Act of 1970, the CSA, as you know, marijuana is classified as a Schedule I substance. This means that the federal government deems the drug to have a high potential for abuse and dependency and no recognized medical use or purpose. But starting also, as you know, early in this century, state decriminalization of marijuana has been on a steady rise. My research indicates that as of today, all but 3 of the states have adopted laws permitting marijuana usage for medical reasons, and 18 states in the District of Columbia have enacted programs allowing it for purely recreational purposes for people 21 and older. So the question is, how do you reconcile the federal criminalization scheme with these emerging state regulatory schemes? And as I said, there is no easy answer to that question, but we have a few clues that I think will guide us. First, there are emerging court decisions in a few states that have addressed challenges to the state programs, and those challenges are essentially not entirely, but essentially based on arguments that the state programs are preempted or overruled by the federal law. And second, the ever-evolving guidance documents that I'm sure many, if not all of you know, have emerged from the Department of Justice starting in 2013, and which seem to vary based on the person who's holding the office of president at the time of the issuance of the guidance memo. And based on those clues, given the time that we had available to respond to these questions, I do not want you to think that this memo is in any way intended to be an exhaustive inquiry, but our limited review of the court decisions handed down thus far, as well as DOJ's current pronouncements, give us a measure of confidence that the Commission's adoption of the proposed regulations will not trigger any enforcement pushback. On the litigation program, most of the litigation has occurred in a few states, most notably in California. And one of the principal arguments advanced by the states who are promoting and promulgating these decriminalization laws is that the CSA does not preempt, i.e. overrule such local initiatives under the Supremacy Clause of the United States Constitution. And the bottom line, and I'm not going to read the footnotes, I refer you to those, and I'm happy to answer any questions, is that that argument has proved successful in some cases, but not in others. And as of today, the U.S. Supreme Court, neither it nor any federal appellate court has weighed in yet on this preemption issue. And as the commentators that we've reviewed all indicate, there is no trend line that appears to be emerging, and there's no consensus in the literature tracking the court decisions as to which is the better line of cases. So unless and until the Supreme Court actually steps in and addresses the issue head on, there's going to be the uncertainty concerning the legal challenges is going to continue. At the same time, as you know, Congress, there have been several bills introduced in Congress in the last few years that run the gamut from outright decriminalization of marijuana, in other words, taking it off as a Schedule I substance, to some bills exempt state-authorized cannabis programs from the CSA. And as you know, several of these bills have gained some traction in the House, but not in the Senate so far. So congressional action, we're still awaiting that. Turning to the Department of Justice, again, their guidance to federal prosecutors has varied over the last decade. Probably the seminal memo was issued in 2013 by Deputy Attorney General James Cole. And in that memo, he laid out the DOJ's enforcement priorities. And he stated that if state enforcement programs align with these priorities, the federal priorities, then addressing cannabis, at least for medical purposes, when he wrote the memo, should be left to state regulatory and enforcement agencies. And the memo explained that it was, quote, likely not an efficient use of federal resources to focus enforcement efforts on individuals with cancer or other serious illnesses who use marijuana as part of a recommended treatment regimen consistent with applicable state law. Now, again, the Cole memorandum scope at that time was on state medical marijuana programs, but since its issuance, it was widely interpreted throughout the country as essentially deprioritizing federal enforcement of cannabis laws and creating a nationwide policy that would allow for state cannabis regulation. And following the memo, as I indicated, a wave of states have enacted legislation legalizing cannabis in one form or another. But then in January 2018, then Attorney General Sessions rescinded the Cole memorandum and replaced it with a new memorandum to all federal prosecutors. And in that memorandum, Attorney General Sessions revoked the Cole memorandum's guidance, and it was viewed by some as a declaration of a new federal war on drugs. Attorney General Sessions commented that his memo directs U.S. attorneys to use previously established prosecutorial principles that provide them all the necessary tools to disrupt criminal organizations, tackle the growing drug crisis, and thwart violent crime across our country. But as I indicated, despite that policy shift signaled in the Sessions memorandum, there has been very little change in practice then among federal prosecutors, and very few federal prosecutions of low-level possession charges that do not involve violent crime. There have been very few federal prosecutions taking place since then. And then lastly, the tide shifted again in 2021 after President Biden appointed Merrick Garland as Attorney General. And Attorney General Garland has publicly supported the efforts of several senators who have asked President Biden to decriminalize cannabis and back recreational marijuana. And we found an interesting exchange between Garland and Senator Schatz in Garland's testimony before the Senate Judiciary Committee this past spring. And he responded to a question from Senator Schatz on whether he intended to go back to the Cole memorandum and its position. And the Attorney General said this: as I stated in my testimony on April 26, 2022, the Justice Department's enforcement resources are not put to their best use prosecuting nonviolent low-level marijuana offenses, even in jurisdictions where marijuana use remains illegal. But with respect to those jurisdictions where marijuana use and sales are lawfully regulated, i.e. in Connecticut, as an example, there is even greater reason to conserve prosecutorial resources so that we can focus our attention on violent crimes and other crimes that cause societal harm and endanger our communities. And he goes on to say that the department is examining a range of issues relating to those issues. So in our view, at least under the current Biden administration, we believe it's reasonable to assume that the DOJ will not be authorizing federal criminal prosecutions under CSA for low-level, nonviolent marijuana offenses, and also is not likely to challenge the state's initiatives to establish medical or recreational marijuana regulatory programs. Very briefly, in response to Commissioner Melillo's specific inquiry, the recent position of the Garland Department of Justice appears to rule out, at least for the time being, any concern that the federal government is either willing to bring enforcement actions to shut down state programs, or, for instance, in Connecticut, to seize local tax revenues generated from the sale of cannabis products by locally permitted cannabis establishments. We just don't see any indication that the federal government, at least under this administration, intends to go there. And as I've said, at least one state appellate court has rejected the notion that a city's regulation of marijuana dispensaries, medical marijuana dispensaries, I should say, violates the CA. And that's an interesting case. It's a state intermediate appellate court decision handed down about 5-6 years ago. And there the court rejected a claim that a California city's medical marijuana licensing scheme was preempted by the federal CSA, because the argument was that the city affirmatively permitted rather than merely decriminalized medical marijuana dispensaries. And the court reasoned, and I think this should be instructive for our purposes. The court reasoned that the CSA does not direct local governments to exercise their regulatory, licensing, zoning, or other power in any particular way. And therefore, the exercise of those local powers to permit medical marijuana dispensaries, again, it was limited to medical, but the same reasoning could be applied to recreational dispensaries in our view. The exercise of those local powers that meet state law requirements would not violate conflicting federal law. Again, one case, intermediate state court decision, but provides some guidance. So bottom line is, in our opinion, we see no plausible scenario, at least at this point in time, under which the federal government would claim that by enacting the proposed cannabis establishments or implementing them, the zoning commission in any way violated the CSA. It therefore seems equally implausible, in our view, that the federal government would have any interest in freezing local tax revenues generated by the operation of these establishments in the city. The second question, as I indicated, is it illegal to cross state lines with marijuana purchased lawfully at a licensed Connecticut state establishment? The answer, quite simply, is yes. Under the Commerce Clause of the United States Constitution, travel between states is under the jurisdiction of the federal government, and the federal government still, at least on paper, regards marijuana as a Schedule I controlled substance. So anybody who purchases marijuana at a licensed Danbury facility and then crosses into New York or another state with it is subject to federal prosecution. And the fact that you may have a prescription from your doctor or a medical marijuana card issued under the state program is not a defense to transporting marijuana over the Connecticut border into another state. That concludes my remarks, Mr. Chairman. Again, we didn't try to get too far into the weeds on all the potential legal arguments, but I think we have a measure of competence based on the clues that we find in the state litigations that have come down so far, and the Department of Justice guidelines that it is highly reasonable to assume that there's going to be no federal pushback if you take the action requested by Director Calitro. Thank you.
Thank you, Attorney Casagrande. That was quite a report. It's deeply appreciated by myself, and I'm sure by the commission. Thank you for your hard work. Commissioner members, any questions of Attorney Casagrande at this time? It's interesting. That prior to this knowledge, I'm sure many people thought that Danbury would be a great market because it borders New York, but in reality, Danbury is just like the middle of the state. It doesn't have a market across the line, or they take it upon themselves their own risk. Commissioner Melillo.
Yeah, I have a question and then just a clarification. I want for a clarification just for certainty purposes. First, Dan, since you just went over the memo this evening, I'm assuming because it's not part of the record, we're going to be getting copies of it. Should after we read through the memo, if we do have a question regarding the memo, because you presented it this evening, if we close the public hearing this evening, we will still be able to ask questions pertaining to the memo, correct?
Yes, my memo is legal advice. It's not testimony. So you're entitled to rely on the advice and recommendations of your staff, including the Corporation Counsel, even after the hearing is closed.
Okay, I just wanted to make sure that was on the record, that if we close the public hearing, we would be able to ask questions regarding that memo, since we're just now seeing it tonight. And then secondly, just for clarification purposes, and you went over it quickly, but it sounds to me as though you're telling us that there are no concerns regarding the federal government seizing any city bank accounts or freezing any city bank accounts as a result of receiving tax revenue regarding marijuana sales.
I'm not saying there are no concerns. I mean, there's no guarantee, obviously, but based on our research, I've seen no efforts by the federal government to push back in any way. So again, by the federal government, right, as opposed to private litigants who may be attacking these state laws. I've seen no indication that the feds have any intent at this point to push back on local regulatory enactments. Could that change, with the new administration? Sure. But again, as I said, we have a measure of, I guess I would say, cautious confidence that you can enact the regulation without a reasonable fear of that kind of pushback.
Okay, thank you.
Thank you, Attorney Casagrande. Thank you, Commissioner Malillo. So Attorney Casagrande and Attorney Edwards, we would like to, if we do close it this evening, we'd like to have you back at the next meeting, just in case. So thank you so much. Commission members, any other questions at this time for Attorney Casagrande, Attorney Edwards? Commissioner Hawley, you had your hand up. Go ahead, please.
So I had a question for Attorney Casagrande. In his research or anything, did you find any situations where places in Massachusetts along the Connecticut border or New York border or anything were implicated in any kind of federal scheme or any kind of issue or anything regarding people from Connecticut or New York or Vermont or any of the bordering states crossing into their state lines? Because I know they were one of the first states in our area to legalize marijuana. So I was wondering if there's anything in his research that he came across that they can speak to.
The answer is no. I will say that I've driven over the Massachusetts line from 84 several times in the last couple of months. And I don't know if you remember, but as you go past Yukon, the Stores exit, there's a big billboard sign on 84 that says, remember, it's illegal to take drugs purchased from another state into Connecticut. So, and I'm sure, well, I know that there are, enforcement activities going on close to the state border to enforce that. But in terms of any court cases or positions taken by prosecutors, no.
Thank you. Yeah, I only asked that because I was recently in Chicago, so I saw that dispensary bin that they have. You can just throw stuff in there, like the amnesty box. So thank you for clarifying that.
Sure.
Thank you, Commissioner Hawley. Attorney Casagrande, just curious, where was the billboard, on the Massachusetts side or the Connecticut side?
No, it's on the Connecticut side.
It's on the Connecticut side. So
as you're going into Massachusetts, basically, don't go to Massachusetts and purchase drugs and then come back this way.
So I wonder who's paying for that. I'm wondering if it's the taxpayers of Connecticut or if it's a dispensary committee group or union up there in Massachusetts. Interesting. Very interesting. Commissioner Malillo.
Yeah, just raise a quick, I was just thinking about this. I realize anything crossing over state lines is more of a federal concern than a state concern. But up until recently, it was bringing an item that was may or may not be legal to have in that state. So just theoretically, you purchased, somebody drove over to Connecticut. Let's not say any specific state or location, but drove into Connecticut from New York, purchased some recreational marijuana. And if I remember correctly, I think it's recreational is also legal in New York, or is going to be legal in New York shortly based on the law. So this wouldn't be something that any state, like a New York State police would be enforced, because it would be legal for them to possess it regardless of where they purchased it, correct? It would be more of a federal concern?
It's a federal concern, but I don't want to give you a drive-by opinion on that, because in certain cases, a state law enforcement officer does have the authority to arrest a person for a federal crime. But I would be speculating on when and if that would be appropriate.
Thank you. Anything else?
Just to play counter side, let's just say it was a New York license plate in Connecticut, and a Connecticut police officer, Connecticut state, any Connecticut law enforcement official stopped them because recreational use is legal in Connecticut. Would a Connecticut officer necessarily be charged with confiscating, or would it be, even though it's a New York plate, because it's in Connecticut, would they be okay?
I don't know.
Okay.
Thank you. Commissioner Coelho.
Yes, thanks, Ted. Just had a question. Do you have to have proof of Connecticut ID to purchase in Connecticut? What's the
Yes.
law?
Yes, yeah, you have to prove you have a Connecticut driver's license or other ID, and you have to present evidence that you have obtained a medical marijuana from a doctor who's licensed to practice in Connecticut.
Yeah, that's for medical, but recreational.
If I could just,
Yeah, go ahead,
Mr.
Sharon.
Chairman. Yeah, I mean,
Yes.
when you order online, you have order for delivery, there are very strict requirements in the regulations of the state agencies that I was reading from before about obtaining all the person's identification, the license, the address, the email, the phone number, and then birth date, and then verifying all that. And then at least in terms of delivery, there's manifests that are generated and routes that are generated the day before. So everything is highly tracked, GPS on delivery of vehicles. They want to know where they're being delivered. They want, you got to report that to DCP. And they have to and the person that's delivering, who has a delivery license, has to verify that the person that ordered it is the person to which you are delivering it.
I got it.
So again, assuming it's the name, the address, and everything is exactly the same as the order.
Okay. Thank you. So order in
you.
Connecticut, delivered in Connecticut.
Yeah.
And just one other question. Is there a max amount you're allowed to purchase?
I believe there is. I'd have to go back and check.
Okay. Thank you.
Thank you, Commissioner Coelho. Thank you, Ms. Calitro. Commission members, any other questions at this time of Attorney Casagrande? I'm going to shift gears and go to Ms. Calitro. I had asked her if she can give us some information on surrounding towns. Now that we know that Brewster or New York is out of the picture, what's going on in Bethel, Brookfield, New Fairfield? What do you know?
Okay, so I did some research, spoke to the COG, I spoke to CCM. And so as of yesterday, in terms of the adjacent communities that belong to the COG, Bethel has a ban, prohibition, Bridgewater, prohibition. Brookfield looks like they have a moratorium until May of 23. Ours was just extended. I don't believe there's any regs in Darien, sorry. Greenwich has a prohibition, New Canaan has a prohibition, New Fairfield has a moratorium until November. New Milford, there's a public hearing. I believe it's under the ban column. So I'm assuming it might actually be tonight because it says 7/26. Newtown has a prohibition, Norwalk, it's not regulated. Reading, it's not regulated. Ridgefield, there is a town meeting scheduled for September, and we were just notified of a zoning amendment, which would be a prohibition. So that would be a prohibited in Ridgefield. Sherman, prohibition. Stamford has nothing. Weston prohibition, Westport prohibition except for medical, and Wilton has a moratorium until October of this year. So those are the other 17 municipalities or towns in our region. And then I got a list from CCM of the 169 towns and or cities in the state, and kind of where they stand. I don't know that they're exactly on the same date because some of the things are kind of not up to date with the other, but I do know that the COG it's tracking it for all the municipalities, adjacent municipalities.
Yeah, so the 17 in the COG are just, Danbury would be the only one if we do something then.
Well, some of them don't have any regulations. So remember, it says if you don't have any, you treat it as if it were retail, right? So
Right, right.
could be the case in Norwalk, could be the case in Stanford, Reading, could be the case in Reading, New Fairfield has moratorium, and then Darien. Those are the only unknowns of the other 17.
Wow.
Everybody else, 1, 2, 3, 4 others have moratoriums. Us would be 5. The 4 is 9, and the rest are all prohibitions.
Thank you very much. Commission members,
Mr.
any
Haddad?
questions? Commissioner Malillo, please go.
Could I just request that the list that Ms. Calitro just referenced, including the one from CCM that shows the entire state, even though she didn't identify each of it, that both of those be placed into the record so that we can review it, and then if there's a question pertaining to it, we can ask it.
Yes, thank you. Ms. Calitro, you all set with that?
Yeah, so for the record, let me just make sure. So exhibit 1 would be the cannabis taxes I showed you before. Exhibit 2, the Kramer and Anderson letter, and then this would be exhibits 3A and 3B. Because
Great.
I have,
Excuse me,
Excellent.
Sharon.
yeah,
Sharon, maybe we
Yeah.
want to make them exhibit 5, 6, and 7 instead, because we had exhibit 1 through 4 at the last meeting.
oh, we could do that.
Can we
So
do
then
that?
Yeah,
Yep.
5 is
Okay.
the cannabis tax, 6 is Attorney Casagrandi's, and 7 is, I'll just put them both together, would be
Okay.
the from the West Cog and the CCM list.
Okay, thank
Would
you.
be, thank you, Joanne.
That's one of the things we miss from the in-person. They're usually here on the desk. We go, here you go. This is 1, this is 3. Hey, commission members, anything else of Ms. Calitro at this time? Well, we left everything open, so I think we're gonna, I think we'll have some discussion. I see some repeat faces here. So let me just say, is there anyone else wishing to speak in favor of this petition? Councilman Rotello.
Thank you, Mr. Chairman. Paul Rotello, 13 Linden Place, Danbury. I have a couple of questions, couple of comments, couple of clarifications. Director Calitro's clarification of the measuring of the distances caught my attention. I'm not sure, because Danbury is a community with shopping centers and strip malls. Having an outlet in a strip mall controlled by a single owner may mean that the lot could be 1,500 feet wider than the actual building. So I'm thinking, if we're doing this for a purpose of clarity and we want to measure from, say, point of sale to point of sale, maybe there should be a clarification about a leasehold's borders as opposed to the owner of the property that the leasehold is on, because it could be 10 times bigger than the leasehold itself. So that caught my attention. I don't think we want to, if you have a half-mile-long shopping center and you're on one end of it, count the entire thing, even if the store is 17 feet wide. In Barrington, I hate to keep bringing Barrington up, but it is instructive. There's a shop on Main Street, and I'm not sure if a single owner owns the entire block, but the shop occupies 20 feet of that block. So under these regulations, it would seem to me the current ones, the ones that Director Calitro just promulgated, they measure the entire block, and I'm not sure that that's fair to the process. So that's that. And just a clarification on Commissioner Quello's query. It almost sounded to me as if he was asking if Connecticut would be looking at Connecticut licenses to allow shopping, as opposed to what Massachusetts does. Anybody who walks into Massachusetts can purchase product it's my understanding that you can come in from New York and purchase product in Connecticut with proper New York identification. So I think that needs to be clarified. As far as Attorney Casagrande's point about the billboard, which made perfect sense when it was illegal to consume or possess product in Connecticut, it no longer is and has not been for a year. So that billboard is somewhat superfluous. It may indeed still be at a federal level against the law to transport between states, but there are no billboards like that on the Massachusetts side. And I think that if Connecticut were to start putting billboards up as sort of an anti-competitive program to keep people from buying in Massachusetts, coming back to Connecticut when Connecticut had open ongoing retail outlets, I think Massachusetts would respond in kind. None of those things ever end well. We've seen that with New York and Fairfield County with the taxes and other things like that. So I'm not too concerned about the billboards. It is indeed illegal to transport over state lines. Homeland Security is one of the preeminent law enforcement for that, and they're the area that they patrol is within 100 miles of a border, and that's the entire state of Connecticut because the border is essentially the ocean. So we do have that issue, and until that is rectified, it will always be a concern. But I think it's a minor concern. You don't at the federal level really want to get in front of a freight train, and if Attorney Casagrande's testimony tonight is indicative of anything, I think he said all but 3 states or something like that had some sort of allowance for sales, 18 for adult use and the rest of them for medicinal. So it's obviously moving in that direction. And then finally, just doing license plate audits in Massachusetts. Again, we investigated border state sales in Massachusetts, and not just the New York border, but Vermont and even some of the islands. And license plates were all over the place. Obviously, the 2 preeminent ones, say in Barrington, were Connecticut and New York. There does not seem to be any issue with people from New York or Connecticut crossing the border into Massachusetts to purchase. And I would think, regardless of the status of any federal laws and how long that's going to take, and I think eventually that's going to get straightened out, especially because of banking and interstate commerce. But my opinion is that in Danbury, were we to be the only or one of the few outlets in Western Connecticut, we would see a customer base as varied as what we see now in Connecticut, which is the fact that we draw from New York and we draw from other communities. And then one more thing, Director Calitro mentioned taxes. She did an interesting take on that, where she divided up the estimates by the amount of proposed dispensaries. I think the number was 38. Massachusetts has like 238, and then went from there. When I did them, I simply took the entire state's 3% municipal tax, divided it by the state's population, which is approximately 3.6 million, came up with a particular figure, and then multiplied that figure. This is hypothetical, but say that was $10 a head. I multiplied that by Danbury's population, 86,000, which would give you $860,000. Having said that, this is a critical distinction, and I would leave it to the members of the commission to think about this in the coming weeks. If it turns out we are the only retail outlet in Western Connecticut, or one of the few, that process of simply multiplying the tax, the per capita tax, by Danbury's population would have to be adjusted by a factor, because Bethel will not be participating, Newtown will not be participating, and every community that doesn't participate means more participation in Danbury. I did a back of the envelope, and I got to tell you, we're just sort of, it's by guess and by golly, but I did a back of the envelope factor of 2 So when Danbury had 850,000, it didn't, it was a different figure, but just call it that because it's easier to remember. I multiplied that by 2 to give Danbury a figure of 1.7 million. It could be more than that, could be less than that. But clearly, if we are the only community that allows this, and there is a robust market in Western Connecticut and Eastern New York City, people are going to come here. And that would mean, just by definition, our tax take would be higher because it would include, it would be a regional tax take instead of just a local tax take. And I just wanted to add that to the conversation. Thank you, Mr. Chairman.
Thank you. Ms. Calitro, can you respond to that distance? I'm sure you thought about that. His comment on distance.
Yeah. So again, so the measurement, we didn't, even though there are very few number of establishments that would be allowed under this regulation, we didn't want to cluster, right, in any one particular place. So to ensure that, we just measured from the legal parcel boundary line of a parcel on which there would be an establishment to another parcel boundary line. So if, for instance, you were in a shopping center and the edge of that boundary, the parcel would have to be a mile from the next one. And if that weren't the case, and you could have tenants, next to each other by some distance. I mean, maybe it's 5,280 feet because that's a mile. And so I just felt like we should, and it was consistent with the way we were proposing to measure other things in the regulations. So we just kept it consistent.
Yep, got it.
We could look at it if this is approved and we find that it's not an issue, and you looking at shopping centers and things like that, and say they're more than a mile in width, whether or not. But at this juncture, I just didn't think it was necessary to have two of something that's kind of an unknown attached at one end of each shopping center.
Yep. Thank you very much.
That was the answer to that.
Thank you. Anyone else wishing to speak in favor of this petition? Attorney Mizuko. You're on mute.
I should learn that.
There you
by
go.
now. Good evening,
Welcome
Mr.
in.
Chairman, members of the commission. My name's Ward Mizuko, lawyer here in Danbury, and I was here last time and here again tonight on behalf of D&B Wellness, which is known as The Botanist. And I want to applaud Director Calitro and Attorney Casagrande for their very thorough and comprehensive presentation. I especially concur with the changes to the regulations that the planning department furnished to you in time for today's meeting. So I have just fairly limited things to comment on, if that would be okay. I think the commission has heard very persuasive testimony that the revenue should be quite substantial, the tax revenue that is. And I know there were some comments at the last meeting about, well, will costs erode that tax revenue? I think the answer is really a resounding no. In terms of the collection effort, we're talking about the city receiving from one or two establishments a check and a sales tax return every month. It's hard to believe that a lot of municipal personnel will be burdened by that process, especially since no other type of business in the city pays a municipal sales tax. And because there's no on-site consumption, such as with the case with bars and restaurants, the opportunity for police attention is minimal. And this is especially so because this establishment will have a very elaborate security system and security personnel on site, unlike bars and restaurants. In terms of fire services, it's hard to imagine how it would be different than any other establishment in the city. And in terms of ambulance and medical services, keep in mind that this cannabis is carefully cultivated, inspected, regulated, tested. It's going to be presented to the public in a pure measured format, unlike what's found on the street, which can be laced with who knows what, and which does lead to a lot of ambulance calls, hospitalizations, and so forth. So in light of those factors, I would respectfully suggest that there should be no undue attention or undue consumption of city services by the facility or the people who patronize it. Having said that, I'd like to just turn for a minute to the distance requirements. We talked a little bit about it last time. It was about 10:30 when I got to talk about it, and I probably didn't convey my best presentation at that hour. So if I could just touch on it again and share my screen, I think I can make a couple of points that the commission might find useful.
Sure, go ahead.
Thank you, Mr. Chairman. So this is the regulation we were looking at last time, and trying to get to the right spot. I thought that I submitted a provision on the class of survey, but perhaps I didn't preserve it in this presentation. But let me just touch on that for a minute. The proposed regulation requires all distances to be measured according to the standards of an A2 survey. The other principal option that surveyors use is a Class D survey. And a Class A survey, if you put a pool or shed in your backyard, you know it costs on the order of a couple $1,000s to have a Class A2 survey prepared for your property. But with the 1,000-foot distance requirement, and I'm sure we were all paying attention in geometry class in high school, a 1,000-foot distance requirement equates to about 72 acres. So what the proposed regulation requires is a survey to A2 accuracy of presumably multiple parcels that lie in the 72-acre area surrounding the site. And that's, we all remember pi r squared. It's 1,000 feet times 1,000 feet times pi. So, and then you turn that into acres, it's about 72 acres. So we're talking about an enormous amount of survey work compared to a Class D survey, which would be going to, for example, the city GIS records and determining from them where parcels are located and how they fit together. So I would respectfully request the commission to consider relaxing the survey requirement from A2 to a Class D survey. Is it different from what may apply in some other distance requirements? Yes, but this is a much larger distance. The second part of the distance requirements has to do with definitions. And those I do have in front of you here. And you see that the black is the planning department's proposed regulation, and the red is what we propose as revisions. So for example, the city regulation talks about 1,000-foot distance from a public park, public recreation area, etc. So a public park, you can log on to the city website. About 6 or 8 public parks are listed. You can pretty well identify what they are and where they are. But a public recreation area, what is a public recreation area? If there's a guy who has volleyball friends playing at his house every Tuesday night, is that a public recreation area? I don't know. I don't know what a public recreation area is. And I'd be hard pressed to identify a public recreation area in the city that is not a public park. I don't know what a public recreation area is. So there's that definitional problem. And one of the other uses is a down here, the charitable institution, including any offices thereof, whether supported by public or charitable funds. Well, what's a charitable institution? Is it the Red Cross, the United Way? Sure, everybody would agree with that. But is it also a restaurant that gives its leftover food to the homeless every day? That's a charitable institution. And it says, including any offices thereof. It's fine if you go downtown and you see the United Way sign on a building and you know that's where their main headquarters is. But an example I used last time is if one of the executives of that organization has a home office or potentially works from home, how the heck would anyone know? You can't tell. So it's a severe definitional problem. And what I propose to do is to say that they should be 1,000 feet from a public park, sure. I took out public recreation area, and I limited charitable institutions for the following uses: dependency treatment centers, shelter for the homeless, transitional housing facility. Because I think we can identify them, we know what they are, we know where they are, and they deserve to be separated from a cannabis facility. The other, in addition to some concerns about definition, I also have some concerns about location. And I took out the area, the distance requirement for school bus stops. Is that because I think school children should be right next door to a cannabis facility? Of course not. But who knows what a bus stop is and where it is? When you're talking about surveying with A2 accuracy to a bus stop, how do you go about doing it? You can call the Board of Ed or go on their website and you can see where bus stops are. But those are transitory. They change from year to year. They change during the course of the year. They could spring up at any time, any location. And if a bus stop is in front of this house, if it's a general location, it could stop in front of this house one day, it could stop in front of the next house the next. It's a definitional problem and it's a location problem. And again, we're not trying to endanger school children, far from it. But without a reliable way to know exactly where a school bus stop is, I think the better course of action is to remove it. It has to be at least 200, any dispensary has to be within, has to be more than 200 feet from a recreational zone. That alone should put adequate distance from the dispensary to a school bus stop. So I would respectfully request the commission to consider the changes that I've put forth here. Number one, change Class A2 to Class D survey and eliminate public recreation area, limit charitable institution, and eliminate school bus stop because residential zones are already protected. So, and I should also point out that these potential gotchas that can come with loose definitions and inaccurate locations cannot be cured by variance. That's prohibited under the regulation. And secondly, it's the kind of thing that invites litigation if somebody has a particular desire to shut down or delay the approval of a facility of this sort. And I know Attorney Casagrande is so busy right now that he has no time to take on extra distance litigation. So with that thought in mind, I'd respectfully request the commission to consider these points. Thank you.
Thank you, Attorney Mizuko. Ms. Calicio, would you care to comment now or you want to wait?
I'll wait.
Okay. Anyone else wishing to speak in favor of the, thank you, Attorney Mizuko. Anyone else wishing to speak in favor of this petition?
Commissioner Haddad?
Councilman Chianese, how are you?
Good. How are you this evening?
Good, thank you. Go ahead. You got the floor.
Thank you. My name is Benjamin Chianese, 5 Briar Ridge Road for the record. I'm also a member of the City Council representing the 6th Ward, as with Councilman Rotella, who's on the Zoom call this evening. I'm sort of in the middle of whether I'm for or against it, so I hope I'm speaking in the right portion of this meeting. But my real concern is when I was reading the regulations, is that there is no indication here of lot size of the requirement to sell cannabis at all. I don't know if it refers back to the other sections of the zoning regs, because there's no mention of lot size. Only mention is number of parking spaces required, one parking spot for 144 square feet, I believe. So that makes me to believe if I have a small storefront that's a 10 by 12 by 12 store, and I had a marijuana license, all I need is one parking spot. But the amount of traffic that would cause would be tremendous. So I don't know if Sharon could indicate regarding lot size. I think that needs to be addressed one way or another. And the other question I have is that the regulations don't really address nuisance. Because having heard what the Sharon said and what Councilman Rotello said, that the number of permitted establishments within the greater Danbury area could be 4 or 3 or 2, which would mean that will create such a traffic nightmare of parking regarding those facilities. So to put it in perspective, it's like having one liquor store for the whole greater Danbury area. And you can only imagine what type of traffic that would initiate having one type of establishment for 5 towns. And hearing what I'm hearing tonight, that's a possibility. Because right now, I think what Commissioner Morello also said, that if New York doesn't approve it, and Newtown doesn't approve it, and Bethel doesn't approve it, and Brookfield doesn't approve it, that leaves only Danbury. So they're all going to come here. And there's nothing in the regs that will prevent nuisance. I believe, correct me wrong, Sharon, I think I heard you on the radio about something about charging $50,000 or something for police type of coverage, but I don't see anything here in the regs that would authorize such a fee. So I wish if that could be addressed a little bit more, that could help me with my concerns as well. So those are some of the 2 concerns that I have. Also, for the record, I did inquire to Corporation Counsel Casagrande and Corporation Counsel Les Pinter regarding the legislative authority in this matter, whether the council could overstep and approve something against zoning. And there was a memo that they did write, and I would like to share that memo with the commission, but I don't know how to do that. So
Maybe Ms. Reed can help you out on that. I don't know either.
but maybe if Attorney Casagrande has that memo handy, maybe he can share it and he can go over it, because I think it actually addresses a lot of the points that were made at the last meeting. And I think it will kind of clarify who has the right to do what. And I think that's a good document to have part of the record. So at this point, I don't know if you're going to continue the public hearing tonight, but it sounds like from Attorney Mizuko, his request is to do such that, because his concerns need to be addressed as well. So those are only 2 concerns I have this evening. Thank you.
Thank you. Ms. Calitro will address your concerns. I know that the $50,000 issue is a state thing. It's not in the city regs. She'll talk about that. Attorney Casagrande just unmuted. So I think Attorney Casagrande, did you want to address that one issue now?
Well, I don't know how to get my memorandum to share that tonight. And frankly, my memo, which we sent to Mr. Chinese, and I think Paul Rotello as well, that gets into the question of what body in the city has the authority to adopt these regulations. And respectfully, that's a legal question. In other words, the zoning commission is being presented with a petition to adopt a regulation. There's no question under the state statute that the zoning commission of a municipality has the authority and the jurisdiction to adopt these kinds of regulations. Whether the city council has, concomitant authority, in my opinion, I believe under the charter, the authority is properly reserved to the zoning commission because that is the body designated by the charter to promulgate zoning regulations. And so in my opinion, the authority is properly reserved to the zoning commission. But I guess my concern and my hesitation is that that's not a question that this commission has any real legal authority to address. You see what I mean? And so I certainly appreciate Ben's comments. And I can certainly, if you leave the hearing open, I can certainly introduce that memo if you deem it appropriate, but I'm not sure it's going to give you much guidance in terms of what your task is with this application, which is, do we adopt the regulation or do we not?
Thank you. Appreciate it. Commissioner Melillo.
Yes, just curious, Mr. Casagrande, the memo that you're referring to, it's already written, correct?
Yes.
Okay, so I'm curious if, because it was mentioned this evening, and it is a legal opinion to this commission, would we need to leave the public hearing open in order to receive that from you, or could we still receive that from you as counsel?
That memo does not contain any new information or testimony. It's purely a legal opinion. So again, I don't think you need to leave the hearing open in order for you to consider that memo after the hearing closes, because it's really legal advice.
Right, because I remember at the last public hearing, I think I asked you, I had brought up the possibility of being in a quagmire where we did something and the city council may have taken something else and we were at conflict. So I think that is probably even consistent with that question. So that's why I was thinking that I don't know if we would actually have to leave the public hearing open to specifically receive that piece of information from you.
I forwarded to Joanne. She has it.
Yeah, I don't think you need to leave the public hearing open.
Okay. And it sounds to me as though Ben sent it in. So if that's like Ben standing in front of us in city council chambers and giving it to Joanne, he just emailed it to Joanne. So we can probably recognize that it was submitted tonight also, if you wanted to, Mr. Chairman.
Thank you. I mean, this petition is in the proper place, and we'll do what we have to do. And whether the common council agrees or does something different, it's not for us to consider at this point, I don't think. I mean, this petition just found its way to the proper commission in the city of Danbury. So, we're rocking and rolling here. And if the common council does something different or goes along with it or does nothing, we're doing what we're doing, right? Attorney Casagrande?
Yeah, I mean,
We're doing what we do.
Your decision is a narrow one. Do we adopt this zoning regulation or do we not?
Yeah.
And if the city council agrees with it, that's great. If they don't agree with it, that's really a matter for the city council.
Right. Exactly. Thank you. Before I go on to anybody else, any questions at this time for Attorney Chianese or for Councilman Chianese or Attorney Casagrande? No. Anyone else wishing to speak in favor of this petition? Anyone else wishing to speak in favor of this petition? If Mr. D'Amica said, I'm in favor of this petition, he might get a couple of questions. Anyone else wishing to speak in favor of this petition? Oh, Mr. D'Amica, I'm sorry. How are you? Oh, you're on mute. We can't hear you. Nope.
How about now?
We heard a click. We got you now.
Okay, great. Good, thanks. Thank you, commissioners. Just for the record, my name's Al DeMaca. I reside at 53 Old Road Road. I am the Director of Retail Operations for Acreage Holdings, which holds 3 medical licenses in Connecticut, including D&B Wellness or The Botanist in Danbury. I do favor this petition with Attorney Mizuko's proposals for a couple changes. I'm here to answer any questions that you may have for operations on both the medical side or the adult use side, if you have any questions about that.
Thank you. I have a couple questions that seem odd at first, but there's a reason for it. So let me ask you, do medical cards come up for renewal or review by the doctor after certain periods of time?
Yep, it's a year, much like a prescription. So every year, the medical patient has to go back to their doctor or another doctor that will qualify them for another year's worth of medical services.
Has any, to your best of your knowledge, has there been any people with medical cards that their card wasn't renewed or it expired or anything of that nature?
So people have expired. That conversation is really up to the patient and their prescriber. We don't really get involved in that. I mean, we do give them sort of reminders that their card is due for renewal, but then it's up to that patient to go back to their provider to get another year's worth of qualification.
Okay, so if somebody doesn't want to bother doing that and this facility is also selling recreationally, they just may let that card expire, go right over to do whatever their identical purchases or whatever they desire under the recreational side of your store.
Yeah, that's correct. But remember that there is the potency limitations on the adult use side, as well as medical patients are going to have priority both in line and for products themselves.
Right.
Plus, again, the taxes as well. There's no tax on the medical products.
That's what other
there will be. Yeah. So the medical products will remain untaxed, much like any prescription. And the recreational side will have about a 22% tax associated with those products.
About a what?
22%.
The recreational side is a 22% tax?
Yeah,
No.
so 3%. Yeah, 3% goes to the town, and then there's other taxes involved, including state taxes.
Oh, so it's just not the state. It's just not the state 6.5 and the city's
No,
3.
yeah, no, the 6.25% is just more for like accessories. Like if we're selling like a vape battery or some sort of accessory to accommodate the use of the medicine, those products are taxed, and that they're taxed right now on the medical side, but the medicine itself is not taxed on the medical side.
Yeah. The reason why I asked that was because I was just curious as to seeing if, knowing that it wasn't taxed, that if a present customer of yours went from medicine to recreational, then it would be an additional customer that the city would pick up as well. City and state would pick up. Does health insurance or Medicare cover any of this? Any of the purchases on the medical
It does
side?
not. It does not, just because federally it's still a Schedule I classification. It's Schedule II in Connecticut, but federally, and most insurance companies
Will not.
will not. We have had some workman's comp claims that we've accommodated, but regular insurance companies have not yet paid for this.
When I walk into a store and I see a bottle of Pepsi, and if I walked into your store and saw a particular product, let's call it product A, is that the same exact price for someone that buys it with the medical card and someone that buys it recreationally? Or is the pricing of the same product different?
The pricing will be different, and we're not really sure exactly how this is going to work yet. We haven't gotten direction from DCP as far as, will there be two totally separate inventories, or will the inventories sort of commingle with certain medical products only accessible for medical patients? We're not really sure yet. That's still up in the air. But again, in Connecticut, and this will continue, there's not going to be any products that are going to be displayed for the public. It's not going to be like Colorado or Oregon or California, where you could go in and just get jugs of marijuana and smell it and touch it and feel it. Everything is going to be pre-prepared. It's all going to be behind a door or a vault. So the only way that patients or consumers are going to have to see these products is by the online images.
Is that by your choice or is that the state?
That's right.
requirement?
That's a regulation by the state of Connecticut.
That's regulation. Okay. I think I saw Commissioner Coelho's hand go up. You have a question for this gentleman?
Ted, you're reading my mind. You asked the same question I was going to ask. So
Oh,
whether it was state regulation. So thank you.
oh, okay. And then I just want to double check on one thing. If you're only going to sell to someone that has a Connecticut driver's license, you can't sell to anybody that's in Connecticut on vacation, or somebody from New York or Massachusetts. They could take their own chances because of the federal transport laws.
Well, we haven't gotten any sort of direction from DCP as of yet. That question, that question was just raised tonight. I can sort of reach out to DCP. I don't think there will be any regulation stating that we're restricted to Connecticut residents. In the medical side, yes, you have to be a Connecticut resident to have a medical card. But as far as the recreational side of it, I don't believe so. In other states, they don't restrict sales to just in-state patients. So you can go to Massachusetts right now and then purchase with your Connecticut license. You could go to Las Vegas and purchase with your Connecticut license. I don't know if Connecticut is going to do something different. I doubt that would be the case. Again, I think that that's going to be on the onus of the consumer.
So I got a silly question. If I went, let's suppose you didn't exist at this time, because when you do exist, it'll be in reverse. But for now,
my wife says that all the time, by the way.
If I went to Massachusetts and made a purchase and I brought it to Connecticut, it's illegal. But once I'm in Connecticut, if I get pulled over in Waterbury and I have it on my possession, the policeman doesn't, it's allowed in Connecticut, right? So the policeman doesn't know I just bought it in Massachusetts. They would have to be at the borderline and stopping me, right? Or how does that work? How's that going to work?
I don't know. I'm a pharmacist. I'm not a law enforcement. So I really don't know what the answer is there. I mean, I guess if they really wanted to give you a hard time, they can look at the packaging and see where it was purchased from.
Yeah.
But then you could always, get around this and know I got it from a friend or what have you. So I don't know. I don't have an official answer for you. But I don't think that would ever be the case anyways, just because we're trying to decriminalize and, trying to get people out of minor possession charges. So.
Thank you. Commission members, any other questions to Mr. DeMaca at this time? I was right. If you spoke up, we had questions for you.
Sure.
I guess they were all mine. Thank you. Is there anyone else? Thank you. Is there anyone else wishing to speak in favor of this petition? Anyone else wishing to speak in favor of this petition? Anyone else wishing to speak in favor of this petition? Is there anyone wishing to speak in opposition to this petition? Is there anyone wishing to speak in opposition to this petition? Is there anyone wishing to speak in opposition to this petition? Not hearing any. Before I go to Ms. Calitro, who I'm sure has comments, I'll just ask Attorney Casagrande if he has any final comments, or Attorney Edwards if they have any final comments before we go to Ms. Calitro.
No, sir.
Thank you so much. Appreciate it. Ms. Calitro.
Thank you.
Thank you.
Okay, so I think I answered Councilman Rotella's questions on the distances. So I'm going to respond to Attorney Mizuko's questions relative to definition and location. Again, my answers to his suggestions were on the last meeting, so they're part of the record, but we don't believe that we have any definitional problems or locational problems with the way the regulations were written. A public recreation area is not somebody on a volleyball or on somebody's property is not a public recreational area. So let's not be absurd about it. I think everybody's going to, if we find out that down the road that there's some issue with anything, we can always come back to the commission, but we don't think there's any, again, any definitional or locational problems the way they're written, nor do we feel that there is any change necessitated for the survey. It's the same survey requirement, class A2, that's required for a package store. And as we know, liquor is not a controlled substance. So, you know, I don't think it's too much to ask to have their surveyors do the work that's necessary in order for us to ensure that we're protecting the public health, welfare, and safety. So we don't agree with that. We would just leave it the way it is. In terms of Councilman Chianisi's question on indication of lot size, the lot size is the lot size that's required for the zone. So if you're in a CG20, you need 20,000, CA 80,000, IL 40, IG 80. So the underlying zoning district size is the requirements. He talked about question about nuisances and parking. I could just, as I indicated previously at the last hearing, the parking requirement is greater than the regular retail requirement. So the requirement for a lot of parking is in there. And the planning committee, this is a special the regulations are written so that the use is a special exception. Use which requires review and an affirmation by the planning commission that it meets certain standards, and they can deny an application for special exception under appropriate circumstances. And then he had a question about the charges, and that comes right from section 83D of RERACA. I'll read it for you. It says for up to, this is the law, the equitable regulation of that we've been referring to, the state law. It says for up to 30 days after the opening of a retailer or hybrid retailer, and so no microcultivator, hybrid retailer, a municipality may charge such retailer or hybrid retailer or for any necessary and reasonable costs incurred by the municipality for provision of public safety services in relation to such opening, including but not limited to public safety costs incurred to direct traffic, not to exceed $50,000. So that's where that, what you may have heard on the radio. I didn't know I was on the radio, but I guess I was. But that, again, that's section 83D of RERACA. And then finally, again, we drafted these regulations. We feel they're very conservative. Should you choose to go in this direction, we've established that the establishments are highly regulated. The regulations, the way they're drafted, are consistent with the legislative intent of the drafters, as was evidenced by the exhibit of the testimony, the verbatim testimony that we put into the record, the last public hearing from the Deputy Policy Director from the Office of the Governor Mohit Agrawal, relative to those distances and what we could be distanced from. There was some question at the last meeting about the micro cultivators not being allowed to sell on site, and there was some concern about that. And I could tell you again that the regulation of state agencies indicates that micro cultivators may only sell by delivery, so they can't sell there. So our prohibition is consistent with that, the way the state law is written. And finally, I know there was some questions from another testimony at the last hearing relative to social equity concerns. And, you know, we don't regulate land uses based on demographics. And we regulate the land use and not the user. Land with the petitioner or the applicant or their demographic standing. The state addresses those social equity issues at the license stage, and that's really not our jurisdiction. So again, I would respectfully request that everything's, we've heard, everything's in the record. I think we've answered all the questions. We did get, Joanne forwarded it to me, so it's part of the record, which would be Exhibit 8, which is the attorney Casagrandi's legal opinion. And you have 7 other exhibits in the record. And I would respectfully ask that you close the public hearing tonight.
Thank you very much. Commission members, any questions of Ms. Calitro? And you did a great job telling us what's in the record and what's not, so we know where we stand for future reference, future questions, what we can ask and what we can't. Commission members, anything else? Not hearing or seeing, I think we're done. If someone wants to make a motion to close this, if someone wants to make a motion to continue it, Ms. Fay.
I'll make a motion to close the public hearing.
Commission members, Commissioner Fay made a motion to close the public hearing. Is there a
Hi, second Chairman.
Commissioner Hawley seconds it. Any discussion? Any discussion? All those in favor signify by saying aye.
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 All those opposed? So I don't see any hands. I don't hear anything. So this public hearing is unanimously closed. Thank you, everyone.
Thank you.
All right, where are we going? We are going to, there is no old business for discussion, possible action this evening. We have some new business to refer out, a petition of 55 Triangle LLC. Boy, I read this 3 times. My head's still spinning. Petition of 55 Triangle LLC, Bridgeport Roman Catholic Diocesan Corporation, 55 Triangle Street, J15222, for a change of zone from IL40 to RMF4, and at 19 Sheridan Street for a change of zone from RMF4 to IL40. And that's lot number J15219. Public hearing scheduled September 13, 2022. So I would look to get a motion to receive this petition, refer it to the Planning Commission for their recommendation, notify all surrounding communities that need to be notified according to state statutes, publish it in the town clerk's office and all other necessary required publications according to state statute, and set the public hearing as it is on this evening's agenda for September 13, 2022, depending on circumstances related to COVID-19. Who wants to make that motion? Anyone? Mr. Coelho, Commissioner Coelho makes the motion. Is there a second? Second by Mr. Jotty. All those in favor, any discussion? All those in favor signify by saying aye.
Aye.
All those opposed?
Who seconded? I'm sorry, I missed it.
Jotty, Commissioner
Okay.
Jotty.
Okay,
Okay.
okay.
By the way, while we're on the subject of talking about posting, the revised agenda was posted, this evening was posted in the town clerk's office on July 25th, 2022 at 1:17 p.m. Number 2 under new business, application of Pioneer Realty LLC, Steamboat Motors LLC, doing business as Mercedes-Benz of Danbury, 1 and 15 Myrie Brook Road, G18007 and G18016 for a certificate of location approval for a motor vehicle new car dealer's license in the IL40 zone in accordance with section 6A5G of the zoning regulations. Public hearing scheduled for August 23rd, 2022. We have no correspondence. Is there anything under other matters? May I ask Ms. Calitro, is there anything we should know ahead of time on that Triangle Street petition?
No, it just sounds confusing. I was gonna, if you asked me before, it's really a small, it's a land swap for a smaller amount of land over next to where the buses are, but the swap, one piece is in one zone and one piece is in another zone. So it's a very small amount of land.
All right,
But they have to rezone each little piece and then.
each little
combine-
piece.
Yeah,
Nice.
and then swap.
Thank you. For reference only, we have 1, 2, 3, 4. Petition of Maria Lima Takuri, petition of 3775 LLC and Robert Morrissey, petition of 40-44 MPR LLC, and petition of Delaware MMP Realty LLC. You've heard them before. They've been here before. All those dates are August 9th. The first three are. What's added to this evening's agenda is number 4. There is a date scheduled, and it's August 23rd, and that's for the petition of Delaware MMP Realty LLC, which is the property owner, the city of Danbury, for 40 Apple Ridge Road. Change of zone from IL40 to RA40. So that has been given a date of August 23rd. Are there any other matters? Any other matters? And Commissioner Melillo?
Chairman,
Yes, sir.
I just have a quick question in regards to us receiving the documents that were put on the record this evening. I'm assuming we'll get those via email since we're not in person, but will we be getting those in email like soon, or will they be attached to an agenda for the next meeting?
I'd like to see if the sooner the better. If we can get them before the next agenda, I'd appreciate it. Is there any problem with that, Ms. Calypso?
No, they're all in the record. We'll just scan them as one document and send it to everybody. We'll mark them the exhibit number that we indicated, and we'll have them in the next the next day or so, before the end of the week.
Thank you. Shoot them out to us. Thank you. Commissioner Melillo, you good with that?
Yeah, I was hoping to get them and not to receive them just before a next meeting, so we had some time to review them.
Awesome. Thank you. Anything else? Other matters? Any other matters? Any other matters? So at 9:19, I would look for a motion to adjourn. And that would be from, is there a motion to adjourn? Everybody wants to stay? Commissioner Coelho makes a motion to adjourn. Is there a second? Second by Mr. Jowdy. All those in favor signify by saying aye.
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 All those opposed. So we are adjourned at 9:19. Thank you, everyone. Appreciate it.
All right.
Good night, everybody. Thanks.
Good night, Gracie.